All right, good morning. We are live. I'm attorney Vincent Davis, and this is The Secret, How to Fight CPS and Win. I'm joined this morning by my co-host, all the way from Maine, Mr. Darren Guy. Darren, how are you this morning?
I'm doing well, Mr. Davis. Thank you for having me this morning.
A little sound effect there.
Oh, geez, do I? Now, how come you know what? Every time, right? Every time. Isn't my voice? Hold on. Sorry about that. Sorry about that.
Well,
I'm doing well, Mr. Davis. Thank you very much for having me this morning.
I thought you were doing that on purpose.
I kind of was, but then, I don't know what I sounded like, but I hope it was good.
Everybody, I just want to let you know, Mr. Guy is calling us from his $1 million studio in Maine.
Mm-hmm. Mm-hmm.
Anyway, so hey, we have a guest. Hopefully she'll be logging in. She's from Texas. She's having some technical difficulties. But until she comes on, what do you want to talk about? Do you have any questions you want to ask?
You know what? I do want to talk about something.
Uh-huh.
Okori Okorocho is amazing. I spent my day yesterday after we got done. I was working on my website and everything, and I spent my day because I was going to put a link because I put our show up, on my site and everything, and I was putting our stuff out, and I was doing little clips like you do, like for your snippets, but I was doing like our little joke snippets and everything to put them out there, and then to watch the show. I got stuck on watching Okori Okorocha stuff for at least 4 hours. That guy is like, I don't know if you've gone to his site and listened to his cross examinations of the police.
Oh yeah.
Or I don't wow. And then I had no idea about his big fame with the John Travolta thing. And, he's just, he was just, I don't know. It's a good attribute for you. I mean, look at the people you surround with, everybody that you put around you is A plus, top notch. You can do your own research. Connie Rugoli, you got Corey Okorocha. We're halfway to the first Saturday, right? Well, you only got 2 more weeks for that. Do you got any insight on that for this week?
I'm asking some of the same people, and there were several attorneys who originally committed to come on, but something came up, business and professional, and they couldn't make it. Mm-hmm. But I hope to have the same and even more. Fortunately or unfortunately, that means the show may even go longer, packed with information for you. So we'll see.
Mm-hmm.
And I don't know if Connie can come on live. If she can, that's going to be great. But I just might run her entire presentation by itself. That was amazing. And,
mm-hmm.
If I gave that to all of my new clients or my clients and they watched that, they would have so much information, and I think she only took maybe less than an hour, but it was, you watch that, you watch that and you say to yourself, okay, now I get it. Now I get it.
How many times have you watched it? Because you have privy to that stuff. So how many times have you watched the reruns?
I haven't watched the reruns at all. I know that Grace emailed me, I think, and said they were ready. But, I've been busy this week, and I just haven't gotten around to it. So, but I will be watching it.
So look at Jamie. Jamie, we're always praying for everybody that's here, and we can't wait for you to get back. And we totally understand the whole let's not talk on the air about your story. I mean, that's one of Mr. Davis's numero uno things is keep the zipper to the mouth and listen. So good for you and good luck with your case. And we'll be excited for you to come back and tell us how hopefully you kids back. Sorry about that. I just saw that, but wow, that's all I got to say. And then my wife and I spent yesterday looking at YouTube videos of the people that you surround yourself with. And boy, how I wish I would have known you. Probably if I knew you prior to, I wouldn't have had an issue at all. Because number one, obviously, it's the people that you keep in your company. So I would have been on a level of not where I was at that point in time. But everybody is a class act. There's not, and I can't stress this enough. if you need even just a little bit of something to listen to, go to Double O's site. It's I think it's geez, I don't know. I can't. Sorry, it's just brain tooted me. But Corey Okorocha's site is it's pretty awesome to hear that guy fire off the way he does. Like I tell you what, he's worth every dime. I would assume if you need to make sure you don't have an OUI, like whew.
You know, one of the things that you should do is probably friend him, because on Facebook, he occasionally, maybe once or twice a week, posts transcripts where he's testifying as an expert in a very recent court trial.
Mm-hmm.
You know, and I would guess he probably testifies once or twice a week, maybe 3 or 4 times a month. But I mean, they're amazing. They're absolutely amazing. And then
Are you like that fire? Do you fire across like the bout like that?
It depends on the circumstance. You know, he's usually testifying in DUI cases, and they're usually, if you're taking a DUI to trial, it's highly contentious. And one of the things, you know, he's so smart. He's got the degrees. He's also a lawyer. You know, he's a certified civil criminal trial lawyer. So, I mean, he knows what he's doing. And then he's funny. He says something. He says things that are just funny. You know, in the trial, when you know a smart-ass DA tries to take him on. You know, that's one of the big problems with attorneys, especially prosecutors, DAs. And I found this. I did a trial. It's been 2 or 3 years now, a criminal trial, jury trial, and I was going against a 12-year DA, very experienced attorney, very smart, but she didn't know her limits. Right? She didn't know when to fold them. Doesn't know when to hold them, know when to fold them.
Right.
And you know, she came and came and came, and it just backfired big time on her.
Well,
So,
I imagine your experience, right? Your experience holds weight when they want to duke it out in the ring with you, right? I mean, in reality.
Right. But when you're a 10-year attorney, a 12-year attorney, you don't realize that you really don't have the experience of a 30-year attorney. You just think you've reached the top. That's it. You're the best. You know, you're young, you're smart, and you just make that mistake. When I was a 12-year attorney, when I was a 5-year attorney, I thought my shit didn't stink.
Right.
I thought I knew everything.
Like when is the balance out?
Well, you know, it came from me when I was a 10-year attorney. I realized what I didn't know and what I wasn't experienced at. And now that I'm still practicing law, and sometimes I have to chuckle to myself because I see what other attorneys are trying to do or trying to think of, or because it's not rocket science. We're not doing rocket science in the courtroom. Let's face it, it's not.
Right.
Can a layman do it? No, but if you have the experience, it just is something you can't replace. And when I was a 5-year attorney, I refused to acknowledge that. I refused to acknowledge that experience was worth anything. For me, 5 years was enough. I'm great. Hire me. I know all.
You were king of the hill.
Right. And then when I was a 10-year attorney, I thought, oh my God, I didn't know shit when I was a 5-year attorney.
Is there something that sticks out in your head that you remember where you were like, all right, I'm going to go in and you're ready to duke and you just got smacked and you're like, wow.
Yeah. Look, an attorney in town, I think he's retired now. He hired me to do a trial, a PI trial. It was a car accident trial. And I was going against a very seasoned defense attorney from an insurance company. And it wasn't a slam dunk. And but I could have won it. And there was a point in the trial where the expert on the other side is testifying, and he's testifying all this crazy stuff. And I was kind of thinking about it, laughing, like, is the judge really going to believe this? And then at some point, I do object. Objection, Your Honor. Hearsay, foundation, speculation. And the judge kind of turns and looks at me. He goes, it's about time. Like, where you been the rest of the trial? Trial goes on. I lose because a lot of the evidence that didn't that I didn't keep out came in and influenced the judge's decision. I might have been a 7 or 8 year attorney at that point. And I was decent in trials, but I was nowhere near what some of these top trial attorneys do. And it was at that point that I realized that I had to do something to change the game. And that eventually led me to something called the Jerry Spence Trial Lawyers College in Wyoming. And I took a number of weekend courses. It was Thursday through Sunday. And then I got up the nerve to go away for a month and go to the college up in Wyoming. No
Oh,
TV,
nice.
no internet, no phone, just you, and the ranch and your participants. And I met attorneys, trial attorneys, the faculty. They were far and above anything I had ever seen. And they teach you how to get up there, with your skill. Right now, the Trial Lawyers College has been divided because of infighting a few years ago, and the Trial Lawyers College still exists. But Jerry Spence went and formed another trial college. It's called the Jerry Spence Method, and Spence is considered one of the greatest trial lawyers of all time. He did both criminal and civil cases.
Oh,
Um, when I was at the college, I got lucky because we broke up into small groups and one big main group, but maybe 50 or 60% of the month was spent in small groups. I just happened to get lucky by the draw, literally by the draw. Um, I was in Jerry Spence's small group.
oh, wow. That's
Yeah,
cool.
yeah. So he was always talking and sharing and letting us ask questions, and
So that was easy to use that listening technique, right? Because you were there with the man. So like that was very easy for you to just shut your mouth, observe, and just absorb, opposed to having a regular instructor, right? Like you had the man, so you just were like, "Whoa, I don't really want to talk. I just want to listen."
Well, in my small group, there were two instructors, Jerry being one of them, and one what they call psychodramatist. The Jerry Spence method is based on something called psychodrama, and he wasn't the first one, but he folded psychodrama into being a trial lawyer. It's folded into other professions as well, but psychodrama is something very powerful when you're trying to convince people of certain things and get witnesses to tell a certain story that which is hopefully the truth.
Oh,
um, but it's very I spent almost a month in the trial lawyers college. I don't think we ever talked about the law. Can you imagine that? A trial lawyers
well,
college, and we never talked about the law. What we did do is it was highly interactive, and you would learn something and then they would make you do it, right? Do a opening statement or closing statement or cross exam or direct exam. So there was, theory, but it was a lot of implementation, actually doing stuff. And then we did a lot of what they call, I forgot what they call it, psychodramatic acting out.
mm,
Uh, and when I left the college, all this stuff is fresh in my mind. And I had a client, a criminal trial in Pasadena. We were about to go to trial. And I started implementing some of these psychodramatic techniques with him. And on the very last one, I think we did it about 10 times, reenactment of the crime. Um, on the 10th time, he remembered a witness, an objective third party witness who saw everything. He had never told me about her and had forgotten about her, being there. But through the
right.
psychodrama, he was, it was kind of weird when we were doing the reenactment. When he remembered her, the expression on his face was like, "Oh my God,
Mhm.
I've never told you about this witness. I forgot all about her." And from there, we found her, and we found some witnesses that were across the street in an apartment looking down on the event. And I sent a private investigator to interview the witness and say, "Look, is the story as my client tells it or as the victim tells it? And basically, she said, well, it's as your client stated it. The victim started everything, started the fight, the brawl.
Hmm.
And once I got her on a videotape and declaration, signed a declaration, I gave it to the DA. The DA took it to her supervisor and they dropped the case. The interesting thing was he had a co-defendant, a brother,
So,
a younger brother, and he had, a very high-powered criminal attorney in the area, and he refused to talk about or use my findings and techniques, because who was I? I'm
mhm.
just Vince Davis, and they didn't drop the case against him. He ended up taking a plea deal and got a felony on his record.
Ah.
So
What did you say? That's psychodramatic?
psychodrama.
Is that
P.
like is that like mind control type thing? Because watch this. I'm going to show you. Watch this. Do you know I do mind control, right?
No, I
And
didn't know.
I bet you I can do mind control to you right now over this. Watch this. I'm going to show you something. Ready? You got to work with me here because I'm getting a little rusty. All right, Mr. Davis,
Mhm.
I need you to put your right hand up. Mr. Davis, put up your left hand. See that? Mind control.
Got to get you in front of a jury.
Yeah. No, but what's psychodramatic? Is that like how people portray things in their mind and then
Yeah.
they act it out in the courtroom or?
Well, they acted out in the courtroom. It's basically getting to the truth through action. I'll give you a psychodramatic technique that I think I may have talked about this before, but it was kind of interesting when I did this. I did a case, a family law case, and I had a high profile father, and the mother was represented by a woman who's a very good family law attorney, family law specialist. She's a specialist. And we went to trial. And and during the trial, I was using these techniques, these Spence techniques. And during the trial, she was looking at me funny, like something's going on. I don't know what it is. And then I gave the closing argument from the perspective of her client. In other words, I played her client in giving my client's closing argument,
Oh, interesting.
right? Psychodramatic technique. We won the trial. After the trial, because I had done cases with her before and we were kind of professional, and, she comes up to me after everyone leaves and she says, you know, what did you do? I know you did something, but what did you do? You should have never won this trial.
Mm.
So she's smart enough to realize something had happened, but she didn't know what it was. And I never told her.
Oh, so she's living the rest of her days not even realizing that you essentially flipped the script.
Right.
You let her watch her own client give a testimony essentially of, so she was looking at her own mirror, really, of what she was working with.
Here's another psychodramatic technique that I've used. I didn't use this one, I saw it. It was a fender bender car accident. And the attorney for the plaintiff, the victim, gave the closing argument. And he played he was the front fender of the defendant's car. And he described the accident and what happened. Because the
That's
front
pretty cool.
fender saw everything.
Right, right. He screamed, "Oh, it's coming at me!" Like or whatever the car and see the turn, and that's pretty nifty. So all this stuff we talk about all the time. We always get everybody going, "Hey, my they were no good. Inadequate services." Three things that tells you that your lawyer isn't working for you in the CPS case. So, because we always have people like my lawyer screwed me. They weren't working for me. They didn't listen to what I said. What are the three things,
You know,
the three attributes that a lawyer would have that you would say, okay, you should do something?
well, the first thing is, what kind of experience do they have? I'm on a case right now where I'm taking over for a guy who does have experience in the in the CPS realm, but his experience is he's been doing the cases about 5 years. I've only been doing them 35 years.
Mm.
Now, there's experience and then there's experience.
Experience, right. Right.
When you're, like I said, when I was a 5-year attorney, it's hard to admit that. Right? I didn't see it until I got, to this place. So it matters. That's the number one thing. The number two thing is, are they able to respond to you? Because these cases are so personal, and sometimes attorneys they may not call you back. They may not respond to you in time. Even clients, my client, I have a guy that called me Friday night around 9:00. Okay. I was in the middle of something. I didn't return his call, and he texted me this morning, Sunday morning, like at about 6:30. He says, "Why haven't you called me back?" And I thought to myself, well, it's the weekend. It's 6:30 in the morning Sunday, but I just texted him, hey, I'll call you back Monday around lunchtime, which seemed to be, okay with him. But, these cases are so personal. People want response right away, right? 2:00 in the morning. Why aren't you answering my call?
Right.
Oh, I was asleep. I'm sorry.
Right. I'm sorry that you're up, sir, doing the drugs still that you tell me that you're not, but don't call me at 2 in the morning.
That's the second thing I would probably ask. The third thing, I was going to say experience again, but maybe knowledge of the law. What training do you have? All right. So here's the thing. And I learned this at the Trial Lawyers College. Every attorney knows the law. Okay? Every attorney does. How good of a trial lawyer are they? That's the question. Because if you know the law, but you don't know how to prove things or defend things with the evidence code, with objections, with trial strategy, if you know the law, that means nothing. Many years ago, I had an attorney that worked for me that was doing a trial, a family law trial, as a matter of fact. And she asked me to come by to watch the trial. She was going against a very, very well-known family law lawyer. Very well-known, very well-respected. In the past, I had cases against him, but we never went to trial. I watched him in trial. Darren, he was probably one of the worst trial attorneys I've ever seen.
Yeah.
Ever. But he was like a 25-year attorney then.
Mm-hmm.
Well respected, knew the law.
Mm.
But he didn't know how to be a trial lawyer. Let me give you an example. This drove the judge crazy.
Yeah.
When he was asking questions, the witness was to his front, to the right. He would walk around the courtroom, literally walk around the courtroom, and he'd take off his glasses and he'd twirl them like this as he was asking questions. Finally, the judge says, "Counsel, would you stop twirling your glasses? It's distracting me." Now, remember, you're trying to convince a guy who's the judge, one person jury, and you're distracting him, and he's told you you're distracting him, and then you continue to do it because that's what you've done for 25 years.
Mm-hmm.
And then at some point, the judge says, "Hey, man, just stand on your side." He literally is walking all over the courtroom.
I had a friend of mine that was in his case, the same thing. It was to the point that my friend was actually telling his lawyer the questions to ask. He said his lawyer was standing there like a Nimrod, and the judge was continuously asking, "Are you going to continue? Are you all set? Have you done?" Literally kept my friend on the stand for 3 hours. And he said each question took 15 to 20 minutes because the lawyer just stood there dumbfounded, and he would just sit there and breathe heavy and to the point that clearly, I guess he was irritating the judge. So yeah, he didn't stand a chance. It's crazy. But
And
how do you know that they're going to be like that?
right. One of the things I had trained my lawyer to do was, if the guy asked an objectionable question, to object, hearsay, foundation, speculation, whatever. And that was completely throwing the attorney off. And at one point, the attorney says something like this: "She's objecting to everything, Your Honor. Doesn't she want the truth to come out?" And the judge looks at him, because he's sustaining the objection, keeping it out. The judge looks at him and says, "Well, we do these trials by way of the California Evidence Code. Like,
There's a book here, buddy, that you should look at.
That's what we're doing." Basically, like, I don't know what you're doing.
Now, is there anything you can do when you're in that trial and you're seeing your case just tank? Is there anything, like, you as I mean, obviously not you, because you're not the one that's to be tanking. Let's say, like, I've got a public defender. I'm watching this thing tank. Is there anything that I can do in that courtroom where we're in the most important, like you always say, this is the most important case that you've ever been in? Is there anything that you can do to stop the tanking?
Yes. You can ask for a break, a timeout, and go in the bathroom or go down the hall with your attorney and, discuss the matter with them.
Slap
A lot of times you just assume that an attorney who has a law to practice, or has a license to practice law, knows what he or she is doing. That's what you assume.
Correct.
It's not true. It's not true. Having a license to practice law means you pass the bar.
Mm-hmm.
Okay? It has nothing to do with you doing a trial. Nothing at all.
So is there a way that you can, I mean, other than doing your research, but is there a site? Is there something that people can go to be like, let me check this guy out?
No, I don't think so. But you could ask him or her.
Well, I mean, what are you going to say? Hey, are you any good in there or not?
Hey, how many trials have you done?
Right. That's like asking a man, hey, you asking your wife, like, are you any good?
Well,
of course I am. I'm great.
If the attorney, look, I'm going to say, hey, Darren, how many CPS trials have you done?
And I'm going to say one and lost.
No, not even one and lost. How many have you done?
None.
Right. Oh, well, you're not going to be doing my trial.
You're not the guy for me.
I'm nothing personal. I just need somebody experienced.
But you're finding that too a lot in these public defenders, right? Because some of them are from a business circuit, some of them are from a real estate thing, because they're just, I don't know how they're done in California, but in Maine, there's a pool that local, and there was just a big write-up in the paper about this. So in Maine, people volunteer for it. So you get all kinds of attorneys that are available. I think there's an amount that they have to fill or something, that needs to be on the docket to be on the public, available as a public defender. So you don't know if you're getting, real estate Joe or, bankruptcy Betty or whoever you're getting,
you don't. But you remember I told you a long time ago on the show, in California at least, you don't have the right, if you're getting a court-appointed attorney, to get Jotty Cochran.
Right. Because it's not even the law that you have to have, you get an attorney, right? Isn't there some sort of
You can, in some states, some counties, the judge will let you represent yourself. But most judges are going to make you either work with or be represented by a court-appointed attorney, because at least the attorney knows something. You don't know anything. Right. But then, it's all relative. Like on a scale of 1 to 10, 10 being best, how experienced is my attorney? Well, he's a 3.
Right.
On a scale of 1 to 10, 10 being best, how well does he know CPS law? He's a 5.
Better than 0.
Right.
But for the fight of your life, that's the unfortunate. But again, like you always say, there's a way to make money. There's a way to get money. You got to do what you got to do. If you, so you want Mr. Davis, well, you got to sell your toys. You got to do what you got to do to get to that dollar, because, are your kids worth it? That's just the thing.
Yeah, our guest is on.
All right, here she is.
And I think she may be having trouble with the internet, because I see her in the green room. She's frozen. Oh, there she is.
Oh, she's got a kid. That's nice. That's different.
Hey, Karen, how are you? Hey, Karen, I'm going to remove you because we can't have any click on the webinar. Okay.
Yeah.
And you're freezing up, and your picture's very blurry.
There was a lot of things there that went against what was yeah. That was nice to hear, kid, though. I haven't heard that in a long time.
Karen, hold on, Karen, you still have your child on the screen. The child can't be in the picture on this show. So when I see the child is gone, I'll bring you back on, and then we'll deal with the issue of your internet. Because you seem
I
to
hope
be
it's not one of those just little people. I hope that's not what we're dealing with here.
No, I can see them in the green room. It's clearly.
Oh, okay, good. All right. Whew. Well, this world. So what's his face? Oh, I love this guy, the Truth Movement. Among those constraints, and how getting probably prove to a judge at a shelter care hearing because of the rules. So the problem with these things that I'm reading about these shelter care hearings, the 72-hour hearing, as they call it up here, is all of this is just preponderance amount of evidence, right? Like they've used hearsay in that ruling. And that being said, anything that comes out that's hugely against you in that case can be used down the road, right? Because that's a court of record. Is it that now, is that why some attorneys might be like, whoa, Horace, we don't know enough about your case. We're not even going to do this shelter care hearing because, you're charged with 2 counts of armed robbery and, you got a stack against you. We don't need to go in this courtroom.
Well, there is, in my mind, there's no reason to do not to do the shelter care hearing, other than maybe your attorney doesn't want to do it, or, I don't know. And I don't know every case, right? I've never had a case where I didn't want to do the detention hearing, is what they call it in California.
Yeah.
Now, I've gone into many hearings knowing that I'm not going to win that hearing because of the law and the burden of evidence at that hearing, right? But it's easy. I won't say it's easy, but it's important to set up the case at that hearing, even if you're not going to win that hearing, right? Case is long. You got to play the long game. And one of the things that I address is the relative placement. How many times do you go and the kid's in foster care someplace and not with a relative? As a matter of fact, my office just did a case last week where I knew the judge wasn't going to release the kid back to my client. And I explained to my client that. The client understood, but we did get the kid released to the grandparent. Okay? That was a huge victory, because when you get the kid released to a relative, a friendly relative, it's like the difference of having a criminal case and being in jail or being out on bail. When the kid gets released to a friendly relative, you're out on bail and you can, relax because you're not worried about the kid being abused in foster care, or you're not worried about not seeing your kid, or you're not worried about is your kid sleeping. Somebody was texting me yesterday, and the only thing on her mind was that her kid didn't have the blankie. Kid was just taken.
That sucks.
And she told me, I know my kid can't sleep without the blankie.
Yeah.
So I know
man, it kills me.
And apparently the social worker was not responding and didn't give a damn about the blankie.
Yeah. Oh, man.
But when I was a kid, I had a freaking teddy bear I had to sleep with. I can remember
same thing.
3 or 4 years old. Hey man, I'm not going to sleep without my teddy bear.
Yeah, exactly. Right. It's good. Now, let's say an attorney, you're dead set against, you're dead set, no, we need to go to this 72-hour. We got to do this thing. Is that could that be considered in the long run, in the long game, if your appeal goes as an ineffective counsel, where you argued, I wanted this?
It could, but you know what? If I'm an attorney and I say, hey, Darren, I don't think we should do the 72-hour hearing, that's my opinion. Okay. You can't get in my mind to tell me I'm just bullshitting you and want to, go off early or something.
Right.
You don't know. The attorney may have a viable reason for telling you that. It's, the facts and circumstances. But if you're watching this show and, you're learning from what we're talking about, you gotta insist, "Thanks for that advice, but maybe I want to have that 72-hour hearing." I took over a case a few months ago where they did a 72-hour hearing with testimony, and, it actually hurt the client. And it turns out the guy that did it, who was the attorney for the, parent at the time, was a very experienced family law lawyer, but he knew nothing about CPS. So he'd be
Mhm.
going down rabbit holes and black holes, shooting his client in the foot and didn't realize it.
Right. And they're
He
just laying up hearsay as fact down the road or whatever they were doing.
As a matter of fact, I think he was like a 30-year attorney, very experienced in family law. Uh, and I heard that, he was very good cross-examiner. Problem was he was cross-examining about the wrong things, about subjects he shouldn't have gone into.
Mm. We're also seeing a lot of this, and I'm not gonna lie. I mean, I'm one of them too. That I've got my common law book right here. And people using the USC codes. That's my daughter. Like I've spent my time. I've finally gotten up to the point where I'm with you, and it kind of makes me knock on my head a little bit to get my things right. Because I've read things. Like, oh, it says this in this common law, or this is. People talk about color of law. People talk about habeas corpus. People talk about all of these things. Why are they not used in CPS? You don't hear these. You don't hear about them using them. Like for instance, a habeas corpus is to bring the child, right, or to bring the body, right? Isn't that pretty much present the body? Isn't that what that means? Like, um, does that go with the old common law thing of no case, no face, or no face, no case? Like that type of thing, like bring the victim. Is that what a habeas corpus type thing is?
Um, Generally, habeas corpus means it's kind of a legal protection for people who have been imprisoned or whose kids have been taken away. To argue in court that they're being held illegally. Okay, that's what habeas corpus is. All right.
Okay.
However, in CPS law, they tell you the legal and illegal reasons why you can detain a child. So at the detention hearing, for lack of a better term, you are having some type of habeas review, okay, about why the child is being detained, and you're claiming that it's illegal. And the law already says, well, we can detain for these reasons. The problem with the way the law is, I guess, worded, in my opinion, at least here in California, is it gives so much discretion to the social worker and to the judge, right?
Hmm.
So
The definitions aren't
yeah,
defined, if you will.
you might look at a picture and see trash, and somebody else will look at the picture and say it's a masterpiece.
Hmm.
That's basically the issue.
And that goes along with the judge's discretion for the best interest of the child, right? Isn't that
Right. Right. So,
so?
but getting back to your
Okay.
um, question about habeas, does that
Yeah.
make sense? So it's a legal protection for people that are in custody to argue in the court that they were being held illegally.
Okay.
Right?
So what that
But all of those issues come up, and in the 72-hour hearing.
now, so would it be fair to behoove those that talk about it that you could possibly do that, or is that just the wrong remedy for this situation?
In my opinion, it's the wrong remedy. You
Okay.
usually see habeas cases or motions or briefs on somebody that's detained and their trial was illegal and fraught with legal
Mm-hmm.
error. Okay. You know,
Mm-hmm.
um, give you an example. My office did one time. Guy got convicted of crime. 5 years goes by. They file a habeas writ of habeas corpus to say that the whole trial was illegal and violated his constitutional rights. Well, they had a right to use that at trial, at the appeals, and now they're asking for usually a federal court, to review that, and the federal court can in a lot of instances. You can do it in CPS cases, but here's the thing: there's something in federal law called abstentionism. Okay, abstention. Okay, it's a very important rule of federal court, and what it says is there are just some areas of law and of life that the federal court won't get involved in because they are too much of a state right type of thing. You remember we've talked about this, state rights versus federal rights.
Right.
You know, generally, and I kind of chuckle when I see this, generally, parents who are conservative for every other thing want the federal court to intervene. But their whole basis of their conservatism is that the federal court should stay out of it and that let the state decide, right?
Right. You're a Republican one way, but a Democrat the other.
Right.
Right.
So what you can do is if a kid is detained, you can go through all this, you can file a writ. But one of the things the court might say, the court could just deny it. Court might say, you know what, custody of kids is a thing we don't get involved with. That's a state rights issue. That's clearly for the judge in the state court. We don't do that over here in federal court.
Okay.
And so then you're kind of scratching your head like, well, I got to, pound it out and fight it out in the state court. And that's the CPS court. So you can file a writ, okay? A good writ is going to cost you $30,000, $40,000 estimated.
Wow.
Okay.
Holy smokes.
So you can spend the money. I'm sure, there'll be, someone who willing to run it up the flagpole and see if anybody salutes.
Right.
Have I ever heard of a writ of habeas being successful in a CPS case? Yes, I have. But I can count them on one hand. And I've been doing this 37 years this December. So it's like one of those odd, when you play the odds, you hit 20 on the blackjack table.
Or you're playing the Statue of Liberty in football, you're like, oh, they're a trick play.
Right. How many times you've seen a trick play work?
Of course, I'm a Patriots fan.
Right. But how many times have you not seen it work?
Yeah. It normally doesn't happen because it to work. It's a trick play for a reason.
Right.
You're not going to put your money on a let's just Hail Mary this and hope that it, let's let this thing ride,
Okay, look, we got Karen back on. Karen, can you hear us?
Yes.
All right, we got Karen. Hi, Karen.
Okay. So, Karen, where are you calling in from?
Hi. From Magnolia, Texas.
She's just hanging out.
Magnolia, Texas. Okay. So, did you have some?
Yeah.
I don't know if you know this, but your internet connection is not very good. Did you know that?
She still has a very pretty face, but it's just a little blurred,
No, I don't know. It's probably because I'm in that one particular room.
Oh,
well, your internet is slow. And you're kind of like frozen.
Yeah, it's a little early in the morning to say that, though.
I don't lie in Maine.
Hold on.
In Maine, it's 1 o'clock, so we've been up for
a different room.
Good 6 hours. We went out and fed the chickens and.
Is it better?
Feed the cows and all that stuff, and
no,
we see the side of your face.
What I'm going to ask you to do is I'm going to ask you to give me grace and reschedule when you.
Oh, she just fell.
Internet connection. Okay. Thanks, Karen. Unfortunately, Karen had a bad internet connection.
No more Karen.
All right. Well, we've come to the end of the show. Anything else you want to talk about before we say goodbye?
No, nothing enough questions for now. You know, I like doing this with you. You know, it's a good, especially where people, like you said the other day, you know, like, oh yeah, we got to tell people to like and subscribe more too.
Yeah. If you're watching, please like.
And you know what? Yeah. And I think that we need to also remind Mr. Davis about his daily fact points or whatever. Oh, the Truth Movement. Get in touch with Grace. I love this Truth Movement person.
Email grace@vincentwdavis.com. She will arrange to bring you on as a guest. Okay, Mr. Guai, I want you to have a good rest of the day. Sleep.
I'm going to the dump Sunday.
All right. And
Do you
I'll
have a
see
dump?
you
Do you guys go to the dump in LA?
No.
Yeah, you will.
I mean,
but do you guys have a dump in LA?
Yeah, we do. You can, but you know, the trash people pick it up.
Yeah, that must be nice. But there's a lot of cool things at the dump, though.
We'll see you
All
tomorrow
right,
at
Mr.
7
Davis.
p.m. Pacific Standard Time. Bye-bye. Have a good Sunday.